Growing up on a farm in the Eastern Cape, Wesley Hayes always knew he wanted to be a father, but he was clear it was something he was doing on his own.
I couldn't really imagine myself with anybody, and also there would be no bickering with and maintenance issues and custody issues.
Oh, you're a divorce lawyer?
Well, I do a fair number of divorces, yeah. So, you know, you see always the children being pulled between the parents and being used as a pawn. So initially I thought, well, it was impossible. And then I studied the law and realized, okay, it is possible.
Wesley runs his own law practice in Komani and started the journey towards fatherhood 6 years ago. At a fertility clinic, he went through numerous tests and then chose an egg from an anonymous donor with the closest possible match to his family genes. Using his sperm, they fertilized the eggs and 10 embryos were frozen. Wesley had to jump through so many hoops just to get the green light to have this child on his own. He has been psychologically, socially, and even financially assessed. After going through tests with 7 potential surrogates, all of which fell through for various reasons, Wesley was on the verge of giving up on his dream when he finally found a surrogate in his hometown. What was the response from your family and friends?
Well, I never told anyone. I sort of went on my mission myself. My folks were quite shocked but happy.
Sadly, Wesley couldn't be at her birth because she was born during COVID restrictions, so he waited anxiously on the farm when the surrogate went into labor. The call finally came through at 3 a.m. that Justine was on the way.
So when I got there, she'd already been born. I immediately recognized her. I knew she was mine, and I just started crying.
Wow.
They said I must sit in a chair and take off my shirt, and they put her on my chest. And I just cried and cried and cried. It felt like an age because it had been coming for a long time, you know, and now it was real. And there she was. And here she is.
And here she is.
Yes, no, what's this one?
After waiting 6 years to become a father, Wesley pitched up here at the Department of Home Affairs a month after his daughter's birth, filled with excitement and expectation to name and register his child.
So I took my file down to Home Affairs, and I mean, the queue was just unbelievable. And it was 3 days before I got into Home Affairs. And immediately the lady said, where's the mother's details? I said, no, there is no mother. She's born by surrogate. I'm a single dad. Here is the surrogacy agreement. Here is the court order. And she said, this can't happen. We can't register without the consent of a mother. There has to be a mother. And then I realized that the Birth and Death Registries Act doesn't allow me to register as a single father. And then that's when the problem started.
Advocate David Smith, who has taken up Wesley's case, discovered that despite the Children's Act providing for surrogacy and anonymous egg donation, the Birth and Death Registration Act has only 4 categories under which children can be registered.
A child born either in or out of wedlock, a child born outside the borders of South Africa, or a child that's an orphan child. The problem here is that Wesley can't go alone to Home Affairs to register his child's birth. Wesley would need a mother to accompany him to the satisfaction of Home Affairs. A mother doesn't necessarily have that same problem because a mother can go alone to Home Affairs without the father.
So I couldn't explain to anybody that she was born by surrogate, put the surrogate's name there. And I was like, no, she's relinquished her rights and responsibilities to the child via the surrogacy agreement, which has been made an order of court.
Director for the Centre of Child Law, Karabo Oza, says same-sex couples face similar problems.
The challenge they face is this. Home Affairs tells them that the form only recognizes one mother. The minute you need to add 2 mothers, they don't know what to do. And then Home Affairs say to them that if they conclude a life partnership agreement, they will add the other mother. But now you are kind of forcing people to comply with requirements that are not even in any law for you to actually register the birth of the child.
When Wesley wrote to the Department of Home Affairs, the state attorney said he could register Justine if he put born from surrogacy under the mother's details. Karabo advised Wesley not to accept this offer.
That's problematic because you are labeling the child, and also the Children's Act has privacy provisions in relation to where children have been conceived via surrogacy. It gives the power to the parent to disclose when and how. Surrogates are guaranteed their privacy because they actually, in the court papers, they are anonymized.
The problem is that the Birth and Death Registrations Act is out of sync with the Constitution and the Children's Act.
The problem we have is that our Birth and Death Registration Act is actually outdated. So even though we have recognized surrogacy agreements and people have been doing surrogacy since the Children's Act came into operation, the Birth and Death Registration Act, there was never a process of putting provisions there to enable the birth registration of children born through surrogacy agreements.
As a father, you now realize that your baby daughter does not have an ID. What is the impact of that, and what does that mean?
I mean, she'd be unable to inherit because she wouldn't be a legal person to inherit from me, and she'd be, in essence, become a ward of the state. My parents wouldn't really have a rightful claim to her, and besides that, I can't agree to any urgent surgery if she needs surgery. Medical aid is a problem. Insurance is a problem.
Just everything?
Everything, yeah. Everything that flows from being a registered individual and state, besides not having a name and not having a right to a nationality and so forth and so on.
What are some of your worst fears around this?
My worst fear is me dying, without a doubt. I mean, if I were to die, I mean, you know, who takes care of her? I mean, that's without a doubt the worst fear.
Having done this whole process on his own, Wesley was surprised to learn recently that surrogacy attorney Robin Friedman had assisted at least 20 single dads, both straight and gay, to register their children.
So we have a surrogate motherhood agreement, which is entered into between the commissioning parent, because we're focusing on the single parent at the moment, and the surrogate mother and her husband or partner, potentially, because he's also involved. And then there's a High Court application which accompanies that agreement. So we ask the court to confirm our surrogate motherhood agreement. And we also request the court to direct the Department of Home Affairs to register the birth in the name of the single dad.
I was completely unaware that that was the practice that was taking place. And as an attorney, I cannot see how it is possible to order a department to do something without having cited them as a party to the proceedings.
Does the Department of Home Affairs have a right of reply? Are they cited in the document? And if you haven't cited them, is that not problematic and you've had no issues going forward?
I've never ever had a judge raise a query with me that we haven't cited the Department of Home Affairs because it follows from the Act. The Children's Act specifically states that from the moment of birth of the child, that the child is the child of the commissioning parent or parents.
The Department of Home Affairs says Wesley's case isn't unusual, and they have assisted other fathers to register under Section 9 of the Birth and Death Registrations Act. They recently tried to assist Wesley to register his child.
They have made an offer to leave off the mother's name completely, but Wesley's intention is that that's not good enough. There must be a provision in the Act for children who are born without mothers.
Home Affairs' kind of response is always to try and say, well, we can accommodate you if you do 1, 2, 3, 4. But that discretion is problematic because somebody in Eastern Cape will be treated differently from somebody in Pretoria. You know, it depends on who you get that office helping you, but you must always escalate. So that shows you there's a gap in the law. The law does need to be amended.
As a father, it was tempting to accept the Department of Home Affairs offer. But as an attorney who acts for the Mandela family, Wesley feels compelled to follow the law. Otherwise, he thinks it'll make Justine's ID document open to be challenged in the future. After nearly a year of trying to resolve the problem with the Department of Home Affairs, Wesley turned to the courts to try and get his child registered.
So the application is in 2 parts. There's a part A, which we're asking for as an immediate relief to have her registered, and that the part B is that the law gets amended, that men in future in the same or similar situation to what I'm in don't have to go through what we're going through.
The Department of Home Affairs says it's reviewing its policies and laws to more accurately reflect the realities of our evolving society.
Did you see your dad?
Has it angered you that you'd have to go through all of these hoops?
Initially, no, but recently, yes. It is annoying that I have to do it, and it should have been done years ago. I don't know how old the oldest child is that was registered through this way, but that person should have been the first person to have done it.
In a groundbreaking judgment, the High Court in Makhanda acknowledged that baby Justine was born of surrogacy to a single dad and instructed the Department of Home Affairs to register her birth. On her birth certificate, Wesley will be reflected as the sole parent, and under mother, it will read, not applicable.
Well, immediately it means that she's recognized as a person, and I'm recognized as her father, and now she can inherit my horses. Yeah, I just think it's going to make it a lot easier for people who follow, that they don't have to go through the process that we've had to go through and the angst that has culminated from it.
Next is the High Court challenge on the constitutionality of the Birth and Death Registration Act. Both Wesley and Home Affairs will make submissions. If Wesley is successful, it will go on to the Constitutional Court.